So it's not usually the lawyer's fault, right?
Right.
I mean, but we take the fall for a lot of people. A lot of times a woman or a man will say, I don't really want him to have a lot of time, but I'm afraid to tell him that. So I tell him, and I say to the judge, our position is that he or she should only visit Friday to Sunday. I might tell my client, I think that's wrong, you should offer more time, but it's their life, and sometimes they hide behind us. So people get mad at lawyers, but good lawyers, and judges who were judges that now serve as mediators see this. Good lawyers, before they go to court, do everything they can to get their client to settle. I will tell my client, you can get the same result by settlement instead of going to court, or you can get close to the same result, or even if you get a little bit less, you save the aggravation and the cost. I clear my soul, I clear my conscience by doing that, and when I go to court, I know I've done everything I can to get my client to compromise or to make a reasonable offer. And sometimes the other side is the problem. They don't take the reasonable offer and they don't make a reasonable offer, so we go to court. But do clients or the other side get mad at us? Sometimes, because they think that, if we didn't play our role, they would have gotten more money. But I'd like to think, and maybe I've evolved and maybe it's more as I get older, that I'd like to feel like if I ran into somebody whose spouse I represented, and maybe I'm just dreaming, but I'd like to think that they would look at me and say, Mr. Kessler, I hated you because you represented my wife, but I realized you had a job to do, and you were respectful to me when you were in court. And you were respectful to me, and in fact, I think you probably tried to get her or him to be a little more generous than they wanted to be. And I appreciate that. I hope they would feel like that because I'm representing my client, but it's not my life. My job is not to go in there and ruin the other person's life and make sure that they're miserable and poor and don't see their kids. My job is to let them all come out of it so that they move on in their life, and that they can move past it and not be resentful because she said something in court that he can never unhear, and vice versa. Settling a case has a lot of fringe benefits. You never see your spouse get on the witness stand and point the finger at you and say you're a terrible person. That's worth something to me.
Now, are there ever any jurisdictional issues that can make divorce law?
Yeah, jurisdiction's a fancy word for which state are you going to be in or which court are you going to be in. And that comes up all the time, especially with athletes, and I don't want to keep going back to athletes, but they play ball in different states and they might get traded to different states, and so they started their marriage in Georgia and they get traded to the Portland Trailblazers, so now their divorce might be in Oregon, or they might get, usually there are good rules about where it's going to be. It's usually where everybody lives, but sometimes they start a family in one state, then they move to another state while their family stays in this state, and sometimes it does make a difference. Child support is much higher in states like California or jurisdictions like Los Angeles and New York City and Chicago than they are in Georgia or Memphis, Tennessee. So sometimes people come to me and say, I may be moving to Georgia, I may be moving to California, is there a better jurisdiction? And we have to tell them honestly. I say, I don't know all the laws in every state, but I think Georgia's better or worse than this state, but go talk to a lawyer in that state too, or let me talk to a lawyer and we compare notes. That happens a lot, where we figure out which state is better and should we file in one state or the other. There are some reasons to file in one state. Some states have a 1-year waiting period to get a divorce in. North Carolina, for example. So if you want a quick divorce, you're better off living in Georgia and getting a divorce than you are in North Carolina. So there are some jurisdictional issues, and I've been lucky because I've been very active in the American Bar and other national groups that I learn about some of the nuances in other states, and I'm always learning. There are some differences. Georgia, for instance, allows a jury trial on money issues in a divorce. No other state really does that. So, if you got a case where the other side's really a terrible person, most judges have seen a lot of terrible people, right? They've seen murderers. But a jury might give you more sympathy for being married to somebody who's terrible than a judge. That's an advantage we have in Georgia that some states don't have.
I would think having a jury trial for a divorce matter would be very difficult because you're asking 9, 10, or
12.
I can't remember. Yeah, 12.
So you can agree to less than 12. I did one with 6. It's
6?
I did one because we agreed on almost everything, so we just let 6 people do it.
Oh, okay.
But it's usually 12 people. But there's some reasons for it. Number one, you might have a radical judge who just got burned, him or herself, on alimony and doesn't like the concept of alimony. Or you could have a judge that you have a temporary hearing, and on the temporary hearing they say, Mr. Kessler, your client needs to go to work. He or she shouldn't be getting so much money from their spouse. We say, thank you very much, we'll have a jury. The good thing about a jury is that you have 12 people, so you have 12 shots at it, sort of 12 bites at the apple. If you have a judge, if you don't ring a bell with that judge and make that judge convinced that your client's right, you lose. You go before a jury, there are 12 people that you're arguing to, and juries take things seriously. And I've had this discussion with people on our Supreme Court of Georgia, with lawyers, and most judges, when they sit through a jury trial, they realize juries usually get it right. Because if you think about it, Jordan, sometimes there's a crazy person on the jury that says she should get everything, and there's another crazy person that says she should get nothing. They cancel each other out, and the moderates take hold, and eventually they start saying, okay, $1 million, zero. All right, 800,000, 200,000, and they meet in the middle. So you get a more realistic, moderate result, in my experience, from a jury. I love it so much. I teach a class on it at Emory Law School on how to try a jury trial, and the best thing about teaching is I learn. I always see a student do something that I say, that's clever. You were very, very believable, or that was well thought out. So it's also one of the most challenging things a lawyer does, because judges know the law generally. So I don't have to say, Judge, you know how much child support there should be. Mm-hmm. With a jury, we have to teach them, here's what the law says, here are the child support guidelines, here are the reasons you can deviate from those numbers, here's the things you have to take into account. The child's got a significant learning disability, or there's a travel cost for my client to come visit, and the law allows that, and OCGA, the official code of Georgia Annotated, says that there's a lot more explaining to do with the jury. It's more comfortable with the judge because judges have been there. But it's also exhilarating to prepare for it and to finish it and to leave it in the hands of 12 people and to know that you did all you can do, and now it's up to 12 strangers to make a good decision.
And speaking of jury trials, I really like the voir dire, the jury selection process, because it's
the most important part of the case.
Yeah, it seems like the lawyer, and I was talking about this with another attorney, is that understanding the cultural nuances, to a case versus someone.
Voir dire is when you pick who's going to be on the jury, and it's a misnomer. You don't pick a jury, you strike a jury. So you're given 36, 48 candidates, and between the two lawyers, you have to get rid of everybody except 12. So you're not picking who you want on the jury, you're picking who you don't want on the jury, which should be easier because all you have to do is find out who's likely not to like your client, And if you could be easy, and if I represent a black person, I can say, are you a racist? And they say yes, I get rid of them. But it's not that easy, right? Because you've got to be careful and you've got to be private. And I think a lot of lawyers are sometimes too worried about offending, and they don't ask the right questions. Like I've seen lawyers that will never say, have you been through a divorce? Well, how do you know how you feel about divorce unless you've been through it? If you say yes as a potential juror member, I might say, tell me how you felt about it. Well, I didn't want the divorce. My wife went out and met somebody else and wanted to marry him. And then I think, well, that's sort of like my client in the divorce. So you're going to hate my client because she reminds you of your ex-wife. Thank you very much. And I know to strike you from the jury. It's a very interesting process, and you really have to be able to talk to people and get stuff out of them. You have to ask them, to be brutally honest and to tell you how they might feel if the facts of this case involve somebody who had a problem with marijuana. Would that make you more likely to be sympathetic towards them or less likely? And you might say, well, I don't want to admit anything, but I can understand why somebody might smoke pot, I think, okay, I'm not going to strike him. But I have to be careful because now by asking that question, the other side will realize that guy's going to like my client, so maybe they strike him or her.
That's what I was thinking about, is that do you allow someone to be let me say this. Is it sometimes where you don't strike a juror or potential juror because you don't want the other side to know that person could hurt your case?
Sometimes. So there's an order of striking. Usually I strike one and tell them who's gone, then they strike one. So there might be somebody I really don't like, but I might save them for the end, hoping that the other side gets rid of them first. It's an interesting game. The problem is you never really know what's deep down inside. I talked to a juror after a trial years ago, a jury trial, and my case was about a guy who had 4 girls, 4 daughters, and raised them and got divorced and then married a new woman and didn't have kids with them. And after the trial, the foreperson of the jury, I walked her back to her car because it was at night and I wanted her to be safe. And she shared with me, she goes, Mr. Kessler, I identified with your client's oldest daughter. I said, what? She goes, when I was growing up, my daddy divorced and his new wife tried to take all of our money. I didn't know that because I didn't ask enough probing questions. But you never know what's going to drive somebody. So voir dire is interesting, and it's underutilized, and lawyers don't spend enough time trying to figure out who the right jurors will be. But it's by far the most important part of the case. You get to choose who's making the decision. You can argue all day long, but I mean, you got crazy friends and you got normal friends, right?
Right.
Which one do you want deciding your life? There's some you don't want,
Yeah.
and there's some you do want. You got to figure out which ones are the ones you want.
So my moot court my mock trial was about Batson challenges.
Sure.
And
Which is, can you strike everybody just on the basis of race? That's illegal in Georgia in most states.
And I just found that to be very interesting because on the surface I was like, oh, this is pretty easy. And then as we go through the 14th Amendment and all these different...
But what happens if the 4 black people you want to strike are all people that are really rich, and you don't want them on the jury because your client isn't in their ballpark, and your client, they're gonna make my client pay a lot of money because they're used to spending $8,000 a month on a mortgage and having 2 nice cars, and my client doesn't want his or her ex to get that much money. Well, those people, they're not gonna think that much about, make them pay $8,000 or $10,000 a month because they can afford it. So I don't want them on, but they happen to be black. Well, you got to be really careful in those situations to make sure that you can prove that that's not why you struck them. Just because my client is a white woman married to a black man isn't why I got rid of them. I got rid of them because they were going to have no hard time making my client pay all this money. So it's interesting. And again, the law can only do these general ideas. And Batson's one of those cases. It can only generally say that you can't discriminate based on race. But it can't get into the details, and it can't get into my mind and know why I struck somebody from a jury. And so it's a good law because it makes me be more careful and more sensitive to it, but it's not perfect.
It would seem like now we're kind of hitting on the implicit bias aspect of the law.